So a new justice comes to this court, and they come to you and they sit in your office and say, tell me what I should know about this court that'll make it a better experience. What do you tell them?
I would say you will be surprised by the high level of collegiality here. This term, I think we divided 5-4 in almost 1/3 of all the cases. One might get a false impression from that degree of disagreement.
When architect Cass Gilbert constructed the Supreme Court building, he was told to design a building of dignity and importance. The space given for Gilbert to work with was small, vague, and awkward. Very similar to how much is said about the Supreme Court in the Constitution. It's small, vague, and awkward. Yet Gilbert wanted to ensure a sense of royalty for the Supreme Court and establish their space as an equal branch of government. His solution? Stairs. A Greek-style temple that rises 4 stories above ground. The pillars and stairs were meant to symbolize a superiority above the petty politics that can take place between the other branches. They were meant to signify that justice, through the Constitution, can truly be served in this building. Plus, there is now a basketball court on the 5th floor, considered the highest court in the land. When the Supreme Court building was finished, this great neoclassical piece of architecture, many Supreme Court justices said, nah, we'd rather stay and work from home. And that encapsulates what I love about the Supreme Court. This is our nerdy branch, our geek branch, our outsider branch, wanting to be left alone, uncomfortable with the spotlight, but constantly thrown into it. To be blunt, the Supreme Court has the final say in law. Today, we talk about our third and final branch, the judicial branch. And while this encases any federal court, we are going to be spending most of our time discussing the Supreme Court. There's a lot to explain about the Supreme Court because it's shrouded in mystery. There are no cameras in the courtroom. What we know is based on tradition, audio recorded cases, sketches, and what justices wish to share in interviews or Q&As. So let's get into it. What the heck does the Supreme Court do? Article 3 of the Constitution is dedicated to the Supreme Court, so what does the Constitution say? Not much. There are no requirements like for Congress or the presidency, no amount of judges declared. There are no explicit set of duties or how the duties should be carried out. What Article 3 says in Section 1 is there will be a Supreme Court, they will behave, and they will be compensated. Section 2 says whatever the Supreme Court says goes. A Supreme Court ruling is not just for one state to follow or one group of people. It's meant to review law for the whole nation to follow. Based on the other articles is where we get that a president nominates federal judges and the Senate confirms them. And since they have no terms, they traditionally serve lifetime appointments. When the Supreme Court was initially created, it was 6 judges, often ruling on small land disputes. Today, we have 9 judges who decide the fate of healthcare, gun rights, abortion, citizenship status, all the way to ruling if the phrase "bong hits for Jesus" is allowed on campus. While little is said about the Supreme Court, they improvised the role as time continued. While they are judges, what they essentially do is use a combo of their view of the Constitution and previous laws passed to decide a case. All the Supreme Court needs is a simple majority to decide a case, meaning they need 5 people to agree. But even when a Supreme Court makes a decision, they are giving the ruling, but it's not like they're the ones to enforce it. That's up to federal or state governments to do. Heck, even the Supreme Court limited their own power in the court case you should know about, Marbury versus Madison. Here's what happened. Before John Adams left office, he quickly tried to create more courts and judges so his political views can continue long after he left. One of these judges was Will Marbury. So when Jefferson became president, Marbury asked, where are my papers so I could start doing my job? Marbury had to go to the new Secretary of State, James Madison. Madison refused to employ him, saying, "We don't need you, scram, get." Marbury then turned to the Supreme Court and said, "What they're doing is wrong, and I need the Supreme Court to order this new administration to allow me to do my job." The Supreme Court ruled, yeah, what they're doing is indeed wrong, but we can't stop it. It would be an abuse of judicial power for us to order the executive branch to do anything. That must be done by the legislative branch, not us. We can find something unconstitutional, but not implement any order to replace it. So this case led to the Supreme Court only being able to interpret the law, not enforce it. This power of interpreting law is called judicial review. From the 1900s onward is when the Supreme Court truly became an equally powerful branch. Why? Through world wars, mass immigration, industrialization, and economic depression, of course. The government's role was changing. What? What do you want, Albie? Oh, Albie. Look at him. The government's role was changing, becoming more intrusive, essential, and frightening as they put more regulations on industries, deemed citizenship requirements, created drafts, segregation laws, used nuclear weapons, and created Social Security. While Congress and the President passed laws, we needed the judicial branch, our Supreme Court, to decide if these new laws violated the Constitution. So, how does one become a Supreme Court justice? While there is no age requirement, residency requirement, or job qualification requirement, there is a blueprint now put into place. First, getting a law degree, usually at Harvard or Yale, and they have commonly been lawyers for politicians, clerks for Supreme Court justices before them, or law professors. And finally, through this process, they can often be nominated into a lower federal court first. These are the lower federal courts. You have district courts and courts of appeals. Judges and cases usually first go to these courts. Constitutional cases first pop up in federal district courts. If the losing party does not like the outcome of the case or the ruling, they can then go to the Court of Appeals. If one of the parties still wishes to contest that outcome, they can try to then go to the Supreme Court. But remember, it's the Supreme Court who decides if they want to see a case or not. When a Supreme Court does take on a case from a lower federal court, we call this writ of certiorari. All of this requires time and money. We are talking millions of dollars and plenty of years. But what I want you to understand is based on being lawyers, clerks, professors, or lower federal judges, most Supreme Court justices have experience in law. So here's a look into the day of a Supreme Court. They are asked to review more than 7,000 cases each year, so that's from October to June. From these 7,000 cases, they usually pick between 100 to 200 cases to hear. These cases deal with constitutional dilemmas, where the federal government or state government clash with the person's civil liberties or rights. The Supreme Court is called the Supreme Court because whatever they decide holds more power than any state government. So even if your state government deemed gay marriage illegal, the Supreme Court can say, nah, it's legal, and that's that. All it takes is for justices to agree to review a case. We call this the rule of 4. And once again, all it takes is 5 justices, a simple majority, to decide a ruling. But say you have a case that makes its way to the Supreme Court. Your day in court arrives, the marshal says the famous words,
Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oh yay, oh yay, oh yay.
Court starts at 10 a.m. Monday through Wednesdays. They have 50 seats open to the public, and it's first come, first serve. But remember, no cameras. So you sit down ready to hear a plaintiff or defendant's argument. But guess what? No lawyer is making a passionate speech. There is no monologue taking place. It's not like you're starting the case from scratch. Supreme Court justices, with their clerks, are reviewing past rulings on a case, conducting their own research and context connected to previous laws, and already writing notes and questions here and there. To be honest, in a Supreme Court hearing, the justices are the ones with the spotlight. They each get a chance to ask any question they like, and these hearings usually only last 1 hour, nothing more. Then the 9 justices meet privately once or twice a week to discuss cases in conference. There is a rigid protocol. In order of seniority, they reveal how they are likely to vote. Nobody may speak twice until everyone has spoken once. The most junior justice goes last. The junior justice is expected to take notes by hand on what is discussed and decided, since clerks and laptops are not allowed into the room. The Supreme Court hears cases usually from October through March, and then spends the last remaining months discussing and writing up the majority decisions about a case. They usually save their most publicity-filled court cases to be shared in June. That way they can just go on vacation without reporters trying to hound them with questions at the end. I'll now provide an example of what this looks like through a court case. Roper versus Simmons.
Tonight on a special edition of 2020.
Terrifying home invasion.
An admittedly stupid thing.
The teenage suspect,
17-year-old.
Faces a charge of
confession.
Deceased.
charge in her death.
Accused of murder.
Given the death penalty,
capital punishment.
the suspect is behind bars.
Has been found guilty.
Back in 1993, in the state of Missouri, Christopher Simmons murdered Shirley Crook by first robbing her, tying her up, then throwing her off a bridge. Simmons confessed. He reenacted the murder for authorities on tape, and Simmons' friend explained how the robbery and murder were premeditated. The jury found Simmons guilty and recommended the death penalty. The big dilemma here was that Christopher Simmons was 17. His lawyers argued sentencing a minor to death was a form of cruel or unusual punishment. The question: does the execution of minors violate the 8th Amendment's prohibition of cruel or unusual punishment? Simmons' case was appealed up to 2003, where Missouri State Supreme Court ruled yes, Simmons' sentence violates the 8th Amendment and instead he should serve life in prison. Missouri's Attorney General begged to differ, as well as the superintendent of the prison, Donald Roper, and they requested the Supreme Court to rule on the case. The year was now 2005 with many new Supreme Court justices. So there are 5 different ways or views that justices use to decide a case and view the Constitution that you should know. The first one is the originalist view. This is also known as judicial restraint, textualist, or a strict constructionist. All of these names are just a way to explain that these individuals interpret the Constitution for what the original founders intended it to mean. Nothing more. The words of the Constitution are there. History shows the framers' views through primary documents like the Federalist Papers. If it's not in these documents, the federal government shouldn't have any law interference or protection for it. Because, according to the 10th Amendment, any power not stated in the Constitution belongs to the states. So there is no discussion of abortion, gay marriage, universal healthcare, internet, nuclear energy, climate change initiatives. There is so much not said. and the judges who call themselves originalists believe it should be kept that way.
It seems to me the normal way anybody reads a text is, what does it mean? And if it's an old text, what did it mean when it was written or when it was adopted? Which is why you have glossaries, for Pete's sake.
The meaning is fixed. It doesn't change with how you might personally feel. Some popular Supreme Court originalists were Antonin Scalia, who single-handedly popularized the term, and today we do have Clarence Thomas, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett on the court who take the originalist perspective today. Next, we have judicial activists, or living constitutionalists, who believe they should interpret the Constitution in the spirit of what the framers might want today. So if liberty, equality, and justice are the goals, what would help achieve that in today's world and current issues? It's called judicial activism because an activist approach is claimed to change law instead of interpreting it, often allowing the government to have a more active role in our lives. The judicial activists would claim abortion, gay marriage, and healthcare can be found in the Constitution if we are discussing the spirit of liberty and equality today. The criticism of judicial activists is that they can interpret the Constitution any which way they want. They see what they want to see in the Constitution. Some popular judicial activists are Earl Warren, who oversaw the ruling in Brown v. Board of Education, Miranda v. Arizona, and Loving v. Virginia, Thurgood Marshall, Ruth Bader Ginsburg, and currently Stephen Breyer and Sonia Sotomayor. Third, we have stare decisis. This principle dictates that case rulings and law in the past will be honored and respected with any new Supreme Court decision. Basically, if the Supreme Court said yes something like 10 or 20 years ago, they will honor that decision and say yes again. Stare decisis is a Latin phrase meaning to stand by things decided in order to create some type of stability in law and respect the work of Supreme Courts in the past. This is based simply on tradition. There is no written rule to follow stare decisis, so there are exceptions, but it's a rule Chief Justice John Roberts prides himself by. Another way to rule a case is through popular opinion. Of course, times change. With cultural changes should come changes in law as well. Judges who take popular opinion into account are attempting to be representative of the nation and see the public's view as more important than any legal precedent or ruling issued in the past. One of the primary Supreme Court judges who often used popular opinion through polls and news coverage was the first female Supreme Court justice, Sandra Day O'Connor. The last way you should know how a Supreme Court may interpret a case is one of the more controversial ones, an internationalist perspective. This view takes into account other nations' laws and compares our nation's civil liberties and rights to others, and asks, are we leaders or behind the times in terms of such things like the death penalty, free speech, or gay rights? This view is controversial because the argument against it is international law and culture should not impact what's happening here in the United States. Our Constitution inspired others' constitutions, and so there is a responsibility that whatever is ruled here can influence other courts around the world too. Now, these views are not strict to any one justice, which is how this all played out in the Supreme Court case Roper v. Simmons. Originalists like Scalia, Thomas, and Chief Justice Rehnquist at the time believed that if the execution of juveniles was allowed in the 1700s, it should be allowed today too. Plus, stare decisis established that's what the Supreme Court ruled just 15 years prior to this case. Clarence Thomas even went further, arguing cruel punishment under the eyes of the framers, cited a case in Britain where a man had his innards taken out of him while he was alive. Anything less than that should be up to the states to decide. So that was 3 judges. Another 4, John Paul Stevens, Ruth Bader Ginsburg, Stephen Breyer, and David Soter, took the judicial activist approach and argued that the definition of cruel and unusual punishment has changed because the standards of cultural decency have changed. So that was 7 justices with their minds made up, it came down to two individuals, Sandra Day O'Connor and Anthony Kennedy. O'Connor, favoring public opinion, argued that it wasn't for the federal court to decide because a national consensus had not developed. Out of 38 states that allowed the death penalty, 20 states allowed the execution of juveniles. She argued because states had not come to a shared agreement, the federal government should not make that argument for them. So the court was tied 4-4, and all eyes were on Anthony Kennedy. Anthony Kennedy, from Sacramento, appointed under Reagan, was by all means a conservative justice, yet the more he traveled, the more frequent he became a swing vote in the Supreme Court. Upon visiting courts in India and China, he saw the potential impact on liberty that the United States could have internationally through law. Kennedy looked at other countries' practices and found besides the US, only 7 other nations executed juvenile offenders: Iran, Pakistan, Saudi Arabia, China, and Nigeria, to name a few. Kennedy wrote the majority opinion, and the Supreme Court ruled that execution of juveniles was unconstitutional and violated the 8th Amendment's cruel and unusual punishment clause. I explained this story to show how each justice could rule and how narrow the decision to change our nation and law could really be. It can really come down to just one person. Now let's get into problems of our court system. Each problem can be rooted back to the purpose of the court. It's supposed to be insulated, secluded from political bias and public opinion. But the methods of removing political bias and public opinion have created an environment that does precisely what it was initially against. So first, the appointment and confirmation process already sets up political bias because, of course, a president is going to want to nominate judges who share similar views to them. So whichever political party controls the presidency and the Senate can influence federal law for generations to come. And if one political party holds the presidency and another holds the Senate, usually the Senate gets their way.
I simply ask Republicans in the Senate to give him a fair hearing, and then an up or down vote. If you don't, then it will not only be an abdication of the Senate's constitutional duty, it will indicate a process for nominating and confirming judges that is beyond repair.
Let's let the American people decide.
Within minutes, Republican Majority Leader Mitch McConnell said no. Congress will wait until a newly elected president picks a Supreme Court justice.
But with Donald Trump and Republicans still holding the Senate up till 2020, they get plenty of conservative judges into courts. The appointment process allows political bias. Number 2, lifetime appointments. While most judges have the option to retire at any point, the tradition is federal judges serve until their 70s and 80s. Some do die while continuing to work, like Antonin Scalia or Ruth Bader Ginsburg. While Congress has no term limits, Congress is at least up for re-election every 2 or 6 years. Judges, once they're approved, have that position for as long as they like. This has become even more controversial when the President and Senate approve a judge who might be in their 40s because they can be serving for the next 40 years. Chances are you will be seeing Amy Coney Barrett, Brett Kavanaugh, and Neil Gorsuch win your middle age. This part is increasingly seen as undemocratic. Finally, 9 individuals. While this number is not fixed, and while it has been bigger and smaller in the past, what it really comes down to is just 5 people that can change the course of law and our history as we know it. Each political party raises hell when the Supreme Court's ruling does not favor that political party. Other government decisions involve hundreds of people. The Supreme Court, while they can hear as many opinions as they like, these 9 people have more power than all of Congress for their sheer small number of individuals. These 3 current methods create avenues for political bias and controversy, but the other branches can change this, which leads us to checks and balances of the Supreme Court. While the Supreme Court has the final say in law, Congress and the presidency can check the Supreme Court in a plethora of ways. Congress and the president can pass legislation to change the amount of justices and term limits. Just this past September, after the death of Ginsburg, progressives demanded opening the amount of Supreme Court justices serving, and Democrats even introduced a bill in the House to limit jurists to 18-year terms. But today, like any change made in our government, the process is rooted so deeply in tradition that the fear of change creating instability or an abuse of power prevents any agreement to change. Besides changing term limits and packing the court, the President and Senate have the power of deciding who is in the judicial branch. Finally, and this one might be a head-scratcher, but the President and Congress can also simply ignore a Supreme Court's ruling too. While the Supreme Court can rule a law passed by Congress and the President or by states as unconstitutional, that law can still continue to take place unless someone enforces a stop to it. It's how the Supreme Court decided segregation was unconstitutional in 1954, but it continued for years later, leading up to the Little Rock Nine in 1957. Lastly, the Supreme Court can also check itself in two very important ways. One being dissents. Whenever the Supreme Court comes to a decision, one justice is tasked with writing the majority opinion. Justices are free to write concurring opinions and with different reasons why they agreed to the majority, but justices can also write dissents. These arguments beg to differ with the majority, and they explain why. While dissents may seem like complaints at the time, they can be significant in the future. What they do is lay down the groundwork for future changes in law, and lawyers use Supreme Court dissents in their arguments later on. They can be given as much validity as any majority opinion. Ruth Bader Ginsburg was infamous for her dissents, and a current effective dissenter is Clarence Thomas, who is known for laying out the groundwork for firearms to belong to the individual. Whole constitutional perspectives can change through dissents, and with a change in perspective brings us to this last point. Anything the court does, they can undo. The Supreme Court can overturn their own cases. While typically the Supreme Court respects stare decisis, culture can move fast, and with a change in culture can come a change in morality and a change in law. It's why we have Plessy v. Ferguson and 60 years later, Brown versus Board of Education. It's why Roe v. Wade is constantly in the spotlight for the possibility of being overturned. Now, personally, I love the Supreme Court because they're nerds. They don't like attention, they don't want it, and they take their job seriously. Work and change happen through the Supreme Court, through our judicial branch. It's not like every law the president signs then goes to the Supreme Court, only the most controversial. And they are a complicated body, roughly the same court that allowed Citizens United and Shelby County versus Holder, also allowed gay marriage and DACA protections. While not every Supreme Court ruling can or should be celebrated, it is a joy when people celebrate on the steps of the Supreme Court.
I feel like I just need to be hugging everyone. Everyone gets hugs! Everyone gets hugs! We've been together for 26 years, and we got married in New York last year, but it wasn't recognized in our home state of Ohio. We flew here to D.C., where we're married, and now we get to fly home to Ohio, where we're married.
I'm lucky enough to have lived for the past 5 years in places I can get married, but knowing that friends I have at home that aren't lucky enough to be able to move somewhere else can get married, or I can have a ceremony at home, I can't wait to call my mom.
Because when a Supreme Court decides a ruling, it is change cemented in history, at least for a little while. Thank you for watching. Godspeed.